All right, we're here to talk a little bit about the review for the negotiations and mediation quizzes, and it always kind of amazes me when I listen to law students talk about their concern and worry about a grade and about memorizing certain statutes or certain legal issues, when in fact so often people actually miss the forest for the trees in a circumstance like alternative dispute resolution. We established early on that 97% of cases that you will be involved with from now until the time you retire or die will be non-litigated and most likely resolved through some sort of alternative dispute resolution process. That means only 3% of the cases throughout your lifetime will be tried in a court of law. Now, we spend a lot of time in trial advocacy, in moot court, talking about all the skills and all of the mechanics that are necessary to take a case from a case file, do a case analysis, prepare the case, come up with a theme, and put together a story, and go through to the end of that case for what is hopefully a very successful outcome. But out of 100 cases, you're only going to do that in 3. 97 cases, you will be working to resolve a case through either a means of negotiating directly, mediating, possibly arbitrating, utilizing something like collaborative law. And so it amazes me how many people think that the processes that we talk about are so simple and intuitive and don't really realize how much is involved in this process. Now, I'm going to go over some of the specifics for each of the areas that we've covered, just to make everyone comfortable. But I also want to look back on some of the people that you've had an opportunity to listen to and what they've actually said, and not just what they've said, but how is what they've said, how is that meaningful and impactful on your life and the cases that you'll most likely be working on when you get out of law school and presumably pass the bar. You heard Amy Cuddy talk about the power that we have to basically shape the way we present ourselves and the way we actually can become, simply by altering our body mechanics and the way we present ourselves. We can actually modify and impact hormonal changes in our own body for a better outcome. I've had people that felt that this is in some way trying to change who they are or make them a different person. And if you think about it, that's not at all what this is about. What this is about is recognizing that to be successful as a negotiator, to be successful as an advocate, to be successful as a mediator, to be successful in life, you have to present yourself in a confident and meaningful way. And we talk about intentionality. We've talked about intentionality from the very beginning many, many, many times. And I'm sure most of you have no idea what that is really about. But I'm hoping through some of the things that you've seen some of the discussions we've had that you may begin to have an understanding of what intentionality is. So Amy Cuddy, hopefully you can see, particularly for new law students, I think I mentioned at one point when you're going into a courtroom and you're a new lawyer and you come across an attorney that has been practicing for 20, 30, 40 years, and the judge comes out from his chambers or her chambers and sits on the chair, and all of a sudden there's this communication back and forth about traveling in the same circles through softball teams, picnics, political functions, whatever it may be. There's nothing more demoralizing and scary at just bottom line than seeing that kind of discussion back and forth, because at that point you realize that you're in a tough, very sticky wicket. So Amy Cuddy's presentation, very helpful to get through those kinds of issues. If you're the type of person that really has trouble presenting themselves in an overt way, this can be extremely powerful and helpful. William Ury, Getting to Yes, one of the authors of that very famous book that we still talk about today as it was many years ago when he first wrote it, talking about the power of listening. And I don't know if it's possible that even 10% of you actually have took what he said to heart in terms of the skills that you need to be able to actively listen. We saw you saw the video on mediation mindfulness, the importance of stepping back, of playing dumb, of quiet. We talked about one of the biggest tools that you'll ever have in your arsenal when you're negotiating cases, when you're mediating cases, and when you're presenting one side or the other through an arbitration. There's just simply no tool more powerful than that of silence. It's unbelievable the power that wields and the fear that silence projects and creates in an environment where you're negotiating, mediating. People really, especially lawyers, really have a hard time with silence. And if you learn to harness that power, the results can be absolutely amazing. One of the things that I find odd is that people have a really difficult time understanding why it's important to continue learning about the skill sets that we've been talking about throughout their professional life. That's something I'll leave with you, but that's a significant question people just oftentimes can't seem to answer in a really meaningful and intentional way. When we talk about negotiations and mediation, as we know, are very similar in a lot of ways and yet powerfully different. And many times we can use the power of mediation when we have a recalcitrant client or a position that a client has difficulty agreeing with that we're promoting. But in a negotiation and really in mediation, we're going to follow a plan. Now this goes back to the intentionality that we've talked about, but we're going to follow a plan because we know that in order to achieve the best possible outcome for our client, we have got to follow a plan that makes sense. And it has to be well organized, and it has to be something that we can use repetitively, consistently, And again, something that will provide our clients with the best outcome. So we know that in an airplane, a pilot, every single time before she gets in an airplane, follows a checklist for pre-flight analysis of the plane. Before the plane takes off, there's a comprehensive checklist to go through and make sure everything is checked off. Whether you've been a pilot for 5 months or 50 years, the checklists are used every single time. It's absolutely critical that as part of your intentionality you understand that following these checklists are crucial for you to be successful, to get the best possible outcome. But why? Well, we know in looking at the preparation or at the checklist for example, negotiation, we look at the preparation stage, the first stage, and you could actually spend 2 semesters really just talking about this stage. Now, I've mentioned to you and given examples, and I think some people really think this is an embellishment or an exaggeration, but I have to tell you that probably at least 80% of attorneys simply fail to communicate in a meaningful way with their client and understand or create the kind of relationship with that client where they can actually understand the true underlying needs of the client. And you'll see how all of this comes kind of full circle when we're talking about William Ury talking about the power of listening when he's talking to the president of Venezuela, and how it took him so long to get Chavez to the point where he could just relax his body. When you have a client come in to see you for the first time, and sometimes for the first 3 times, 4 times, people don't like lawyers. Your clients will kind of have initially, most likely have a tepid relationship. You have got to create the environment of building trust and rapport with the client so the client feels comfortable truly sharing with you the good, the bad, and the ugly of whatever the case is about. And one of the things that you will come to recognize is when William Ury talked about Hugo Chavez's shoulders falling or dropping down and his body relaxing. Yeah, we talk about that in difficult dogs. I'm sure you've seen Caesar, whatever that show is, where he talks about red zone dogs and about how he tries to get those types of dogs to calm down and be calm and submissive. But in actuality, that same principle holds true in when we're doing a negotiation or getting people to be comfortable. You can physically see their body change in response to the environment that you're creating. And you create that environment through the process of active listening and making sure that you understand what truly happened, what the client's concerns are, and through that process you'll be able to eventually truly elicit a person's essentials, what's important, and what's desirous to obtain through a negotiation. But that can take a lot of time. It can take a lot of time to break through barriers and walls, and patience is a virtue. The act of explaining a process that to you is so ridiculously simple that you find it offensive that you have to explain it in such a basic manner. But what you don't understand, and what is so difficult, and frankly what separates, as we've said many times, professional athletes from amateurs, they've mastered the fundamentals. And being able to explain the process to a client of litigation and of the process of going through the court system and some of the benefits to that, some of the downsides to that, and then comparing and contrasting the pros and cons of using various processes in alternative dispute resolution. Just providing in a simple, easy to understand, using just basic language, an opportunity for someone that comes off the street that has no idea what any of these concepts are really about, to make them feel that you're not patronizing, that you're not looking at them as someone that's beneath you, but someone that you're simply having a conversation with and explaining the pros and cons will make a huge difference. And we've talked too about the critical nature of setting expectations, because there's nothing worse than going through 1 or 2 years of litigation, and at the end of that time you haven't really set any type of expectation for the client, and now you're asked to go through a mandatory settlement conference or some sort of ADR process, mediation, arbitration, whatever it might be, and now all of a sudden you're talking to your client about numbers that they don't understand, and they don't understand why they can't get certain certain agreements out of the process of negotiation or mediation or arbitration or litigation. They don't understand why it's taking so long. They don't understand why you're coming to them after 2 or 3 years. Perhaps you found out that there's a surveillance tape, or there's some kind of smoking gun or medical records or something through the process of discovery that you've uncovered that's maybe not so beneficial for the other side, and or maybe not so beneficial for your client. And now all of a sudden, after all this time passes, you're kind of dropping a bomb on the client, and they don't understand it. So when you set expectations, clear expectations early on, not just verbally, we've talked about this, and this is a tough thing for people to swallow, but the idea of preparing a letter to your client after you've gone through all these things and kind of outlining what the case is about. We talk about active listening, and part of that is conveying back to someone what you understand this case to be about, and convey what you understand to be their concerns and what they need from the case. Well, it's also important that you can memorialize that in writing, and so they can read it and see that this is what it is. It's also important for you in the future if there's some type of dispute that arises between you and your client for whatever reason. Maybe there was a dispute about the strategy moving forward, whatever it might be, but if you put a comprehensive summary of your client's case and lay out clearly in an easy to understand, unambiguous fashion what the expectations are based on your knowledge of the case at the time, that is absolutely crucial to a very healthy future relationship. Now that doesn't mean that as time goes on and discovery moves forward that you can't modify that. That can these expectations will always be modified and will be adjusted, but you'll have a starting point so that you can always reflect back on, well, we started here 6 months ago based on this information. Now we've moved forward 6 months. We have the other side as an expert. We have more information, some information we didn't have originally. So now we have to reanalyze this a little bit. And as a result of the analysis and the reanalysis, we can say that our expectations have slightly changed and now they're this. Simply explaining that process to the client makes them understand what you're thinking and how you're strategizing a case. If you don't share that information, you may be the most brilliant strategist in the world and most brilliant advocate, but it's all for naught if the client doesn't understand what's happening up in your mind. So the preparation stage in negotiation and in mediation, mind-bogglingly crucial. And of course, the most significant part of that, or one of the most significant parts of that, is establishing our BATNA, our best alternative to a negotiated agreement, where we go through the case, we go through the facts, we look at the damages, we consider the expenses that will be incurred in the case, we consider the likelihood of success if the case proceeds to trial, based on all the facts and evidence, and then we arrive at a number and we work with the client through this process. That is our best alternative to a negotiated agreement. Now, the BATNA, of course, like everything else, is something that will be modified and changed, and it is a very dynamic term, in the sense that throughout the process, as discovery moves forward and as you take depositions and experts come in the case, that BATNA is going to change. But whatever change occurs, you have to always understand what it is, how you arrive at it, and never forget about it as you go through the process. Sometimes it's easy to forget about it as you get caught up in the emotions and the adrenaline rush of going through a long and lengthy negotiation or mediation. Preliminary stage of either negotiation or mediation is really where now it's about you and your opponent, and we can't undervalue the need to understand our opponent. And in fact, backing up to when we talked about what our clients' essentials, what's important and desirous, and in establishing the BATNA for our client, what's more important than trying to work through the same thing for our opponent? Because if we understand what our opponent's needs are, it makes it much easier for us to move forward through the process of negotiating. It's not going to be perfect, but if you really stop and think through any kind of basic case, you will be able to identify, based on whatever information you have at the time that you prepare to move forward with the negotiation, you will have enough to, at least on a skeletal basis, identify the needs and consider what the BATNA would be for the other side. That can't be undervalued, and it can't be emphasized enough, frankly, in the scheme of things. But so with the preliminary stage, when we establish and set the tone of the negotiation or mediation, you've heard the term less is more, but this is a time where more is more. And more meaning more knowledge, more information that you have about your opponent, literally about anything and everything that could help in terms of creating some sort of, at least superficial relationship that can make it easier to begin the facilitation part of the negotiation. I don't want to underemphasize either the value of thinking about your client in terms of where you do these things. Every client, every case that you file, every case is a story. And it's a story that may be fueled by rage, anger, principle, rejection, just gross emotion, whatever it may be. It will always be fueled by one of these things. And understanding that, you have to recognize that you cannot, if you accept that proposition as accurate, you cannot then keep the client out of the process as you move forward. And I say this because it's so often the case that we get busy, lawyers just, they want to move their case forward. And notice I say their case, right? Because lawyers tend to think of cases as theirs, meaning the lawyer's cases. And they actually forget for a moment that that case is someone else's story. It's someone else's life. And so if they get caught up in emails or text messages or phone calls with the opposition talking about resolving this case, they're leaving out the most fundamental part of what this case is about. And I can assure you that to get a case resolved in a meaningful way, when the client is not fully part of the process, is going to leave at some point a bad taste, mostly in the mouth of your client. Clients want and need to be heard. If you have a client that doesn't believe that they've been heard, then all of the things that we've talked about are for naught. And I don't want to, and if anyone tells you anything different, you should be really scratching your head, because as I said before, if we accept the proposition that every case filed is a story and it's about someone's life, someone's anger, someone's need, someone's rage, someone's revenge, someone's justice, whatever the case is, they have something that they need to, a story that they need to tell. They need to broadcast it. It doesn't mean that they have to broadcast it on radio, on NPR, on CNN, or make a documentary about it. But they need to be able to get the story out. If you don't allow that process to work, if you don't help facilitate a meaningful mechanism for the claimant's story to be told, then you're wasting your time and, most importantly, your client's time and money. Now, I talk about this because one of the fundamental things that we want to make sure about is that we make sure the client feels that they are at least on a level playing field. And that is not going to be accomplished by meeting at the other attorney's office or meeting at your office, because one side or the other is going to feel that there's some sort of, it may be a subtle, it may be an unspoken, but some type of imbalance in power because of the location where you're holding this negotiation or mediation. So it's crucial that you consider the objectivity and the of the location that you choose. A courthouse, it can work. Technically it should, right? Because a courthouse is neither friend nor foe to either side. However, there's an intimidation factor in a courthouse. You go through, you almost have to get strip searched, take your cell phone, put it in a locker. It's the antithesis of humanity going into a courthouse. Whereas going into an environment where you are welcome, where there's the smell of food, where there's the ability for people to eat if they're hungry, to drink if they're thirsty, and to use the facilities readily if they need to relieve themselves, and to have privacy, and to not have armed guards and women and men in robes walking around and feeling intimidated. We want to encourage people to feel comfortable. So we don't need to wear three-piece suits to make people feel comfortable. In fact, probably we should be doing the opposite of that, right? I mean, there's not much that makes people feel comfortable about seeing somebody in a tie or a pinstripe suit. I mean, there's just nothing comfortable about that. People will be more apt to be more forthright and tell their story in a more meaningful way when they're comfortable. And all of this goes back to the very fundamental basics of the power of active listening. I mean, when William Ury talks about making a living off of being a negotiator, and really what he's saying is he's made a living, an amazing living off of being an active listener. It is such a rarity to find someone with the true ability to actively listen and to remove themselves from that spotlight, as he talks about, and put the other person in that spotlight. It's such a rarity that someone like William Ury will always be a wealthy person just from that skill. Because very few people can even remotely conceptualize what it means to truly put someone else under that spotlight and completely disregard your thoughts, what how you think you should be presenting yourself in response to something that's said. But to truly put yourself in the shoes of the individual who's under that spotlight and think about what it would be like to walk in those shoes. Wow! What kind of power would that give you? Actually, it can give you unbridled power if you use it, if you learn it, if you practice it judiciously and intentionally. Because it is a skill that you have to use over and over in order to get better at it. Because I guarantee you that if you try using, as an example, the tool we talk about frequently in terms of silence, if you try to do that with your classmates, there's no way that's going to work. You may be able to be silent for 30 seconds, but I doubt you go much longer than that. It's something that you have to build on, you have to practice it, and you have to see it work in order to understand the true power of the things that we talk about through all of this. So we talk about the stages, and we've talked about this at length about we establish identities and set the tone for the process through the preliminary stage, and then of course we talked about the informational stage, distributive stage. When we looked at the interview with Robert Nukin from Harvard, he talked about basically 3 secrets or 3 tenets very crucial to successful outcomes in mediation. And I'd say that's something that you should probably consider in terms of what he talked about. And I'm moving now from negotiation to mediation. You know why? Because it's kind of like they're almost inseparable, right? I mean, they really are. So you had an opportunity to look at mediations in the context of divorce, where you had a dual or 2 mediators that were working through that process, and you also had a landlord-tenant dispute where you had a single mediator working through the process using the more typical tools that mediators use, such as caucusing. And the divorce mediation, in looking at that, there was no caucusing in that, and I wonder if you think about comparing and contrasting those 2 scenarios, what is the value in reality of caucusing, and is it really something that you need to worry about or not? Because ultimately in the divorce mediation, they never did caucus, but yet they did eventually come to some sort of a quasi amicable resolution. But boy, it was dicey for a while. But those are some things I want you to think about in terms of the things you've seen. We saw the live role play, or the role play with these English folks in the context of an employment scenario. You know, what I really want you to think about through all this is not, it's not about identifying a statute or a statutory citation or an acronym, because honestly, if you are not able to do that at this point in your career, that would be disturbing. But what's really crucial is that you understand, when you look at all of these different types of environments with the divorce, the landlord-tenant, the employment type scenario, how all these things interrelate, how all of this interrelates, because in the end it really does. And in the cases where you had more successful outcomes, there maybe were some differences that were applied that weren't used in some of the other instances. So those are some of the things I kind of want you to consider as we move forward towards a conclusion of this this class. And after, of course, the distributive stage, we have the closing stage and the cooperative stage. So, and those stages are very similar in both of the processes that we've talked about. Nonverbal communication, I mean, that is, of course, the primary thesis of Amy Cuddy's presentation, which, by the way, is one of the most viewed presentations ever in TED Talks history. But the power of nonverbal communication is incredible from the standpoint of what you can do yourself using these nonverbal cues. But as important, if not more important, is what you can glean from your opponents and other people's nonverbal behavior. So we know that there are very common nonverbal signals that people give off to create certain ideas. That's all subtle. Of course, they don't really mean to telegraph that, but we know that they exist, and it's typically, I think, important for you as students and as practitioners to know those. And of course, there are common nonverbal signs of deception that we talked about through the lectures, and that's important as well. We know that mediation and negotiation are really not very different, but we talked about the overarching reason that you might want to consider mediation, particularly in the case of having a recalcitrant client, a client that's not particularly fond of your strategic recommendations or your viewpoints, or there's been comprehensive negotiations attempted, but your client, for whatever reason, whether it be principle, whether it be, and let's think about this. When lawyers negotiate, lawyers tend to think about themselves. So lawyers tend to negotiate at one lawyer's office or another, or something more for the convenience of the attorney as opposed to thinking about the needs of the client. And so then what happens is, this big negotiation occurs, and there may or may not be a meeting of the minds between the agents, right, the attorneys. they go back, they communicate with the client, and the client now is feeling that they've been maybe left out of this, that they're not a significant enough part of the process, that they resent the fact that the attorney has taken it to the level that she has and doesn't feel comfortable agreeing with the recommendations made by the attorney. This happens all the time. And you'll find that it's especially going to be more likely when you are negotiating by emails, by text messages, by phone calls, because that is for the benefit and the convenience of the attorney and in no way furthers the case in the mind of the client. And in reality, all this is about what the client wants and needs. So if you involve your clients, I think that you'll find that negotiations can be very meaningful and impactful. However, mediations frequently can become band-aids, and necessary for sure as they may be, because negotiations maybe left the client out just a little bit too much and did not allow the client to feel heard, to feel understood. So mediation, again, is an extraordinarily powerful tool, but it's also a tool that you need to understand and recognize when it's going to be powerful, at what point in the litigation is it warranted, and most important, beyond anything else, who you use for the mediator. There's nothing more important than that decision, because everything rises and falls with the ability and the skill set of the mediator. And time again, you want to look for a mediator that is committed to the process. Because you can have an attorney, you can have a judge that are just brilliant in any area of expertise. They're brilliant. They've written law journal articles, they've argued in front of the Supreme Court, they have gone on Fox and Friends and CNN and MSNBC and every other talk show, and they're just brilliant. But at the end of the day, what is going to win out in a substantive mediation is the ability for the mediator to tirelessly defend the process of the mediation. It's an incredibly arduous and difficult task to truly mediate, because a mediator, you think about it from the standpoint, you have to understand your client's needs, your client's emotions, what your client believes the wrong that needs to be redressed. I mean, there's a lot of things that you have to keep in your head about one person. Now you're asking a mediator to come in as an objective third party and using highly attuned active listening skills identifies what the needs of each of the parties are, and also what's going on with the attorneys in this mediation, right? Because as we heard from Professor Nukin, that's a part of this, is what's going on with the attorneys. I mean, the attorneys have agendas, the attorneys have issues. So we're dealing with tensions involving a lot of different parties. And if you have a case that involves multiple parties, I mean, think about being the mediator there. Now you've got multiple issues that may frequently conflict with one another. You've got parties conflicting with each other. And it's a very complex and very confusing and very difficult dance to engage in actively, meaningfully, and reflectively for 2, 3, 5, 7 hours. It's incredibly draining, and that is why I can't overemphasize the need for choosing and seeking out mediators that are absolutely, unequivocally committed to that process. Very, very important. Now, obviously, all things have exceptions. All rules have exceptions. But for mediation, it's really important. And of course, can mediations or negotiations take place multiple times through litigation? Of course they can. Understanding the areas of law that can help not only get the best possible outcome for your client, but in more and more situations than ever before in the past, for reasons because our world is actually getting smaller and smaller, even though it seems that it's expanding more and more. There are fewer opponents that we can just throw away with the trash, just like we would with a pizza box from Quattro's. It's simply not that easy, and more scenarios involve cases where there's some underlying need for the parties to look to the future, to work in a cooperative and possibly collaborative way for whatever reason it may be. They may be family, they may be integrally connected from a business standpoint. They may, whatever it may be, the parties believe that they have a need to remain together, intact in the future. And so there's almost no better solution for that type of need than mediation. Because mediation at its core is going to look at the underlying interests of the parties and facilitate a meaningful outcome by getting the parties to work together towards creating that meaningful outcome. And of course, unlike litigation and unlike what you can get in court, through mediation and negotiation, you can think very creatively and outside the box, which is why identifying early on, taking the time, the inordinate amount of time, after you've been practicing law for 2, 3, 5, 8 years, you see another client come through the door and you're just going to think, I can't do this again. I can't sit down. I can't go through this idiotic checklist. And I can't do this pre-flight inspection and go through the same rigmarole. When a friend of mine years ago told me that if you are a motorcycle rider and you start worrying or thinking about animals or objects or different things running out in the road like rabbit or deer or dogs, when those thoughts start seeping into your mind, he told me unequivocally, it's time to stop riding a motorcycle. And when you start having those thoughts seep into your mind about, I just can't bear the thought of going through this again, of having to go through and explain this process. It's so stupid. I mean, God, how do they not know this? How do they not watch enough TV that they just through osmosis get to understand this process? You cannot allow yourself to get to that place, because when you do, as with the motorcycle, it's time to get off of the motorcycle and it's time to stop riding. And at that point in your career, if you believe that or feel that way about your clients, it's time to step back. It's time to regroup and either get some more training or just, maybe do a workaround intellectually so that you don't go to that place. Because if you go there, it's going to be a problem inherently. It's absolutely inherently going to be a problem for you if you look at that client when they first come in a different way, in that you just can't do it anymore. It's just too much. It's time for you to step back. I think that pretty well covers the basics. there's no trickery to any of this. This is not patent law. This is not property law where we're talking about the rule against perpetuities. This is actually an incredibly practical and meaningful area that, by you absorbing and learning some of these just real fundamental basic skills and concepts, your life professionally, in terms of the accomplishments that you can attain by using these things, but even personally, you know, the ability to be able to communicate with people in a different way because you look at people in a different way, you treat people in a different way, and that's positive because of the skills that you've learned and absorbed from people like William Ury, from Amy Cuddy, thinking about all the things we've talked about the need for people to get their story out. Imagine having an angry spouse or an angry partner that feels that they've been wrong for whatever it may be. It may be that you didn't get a gallon of milk, or that you did something ridiculously wrong, or that you, who knows what, who cares? At the end of the day, in any relationship, there's going to be both sides where there's screw-ups, right? But the ability for you to allow the other side, or your in personal basis, for that partner to actually express to you and convey and feel that they were able to get their story out, and then for you to be able to talk about it with them and make them recognize that you truly know what they're feeling. Wow, that's powerful. And it sounds so fundamentally just ridiculously simple. But we talked about doctors who time and time again are sued for malpractice because they cut the wrong side. They cut the right arm instead of the left leg instead of the right. How embarrassing is that, to make such a ridiculously fundamental, rudimentary type mistake? It doesn't have to be. And recognizing that pilots that have flown for 50 years will never get in a cockpit without having their checklists in hand, time and time again. Why would you be any different? Why would you practice law any differently than the pilot that you get on the plane with at Southwest when you're traveling to a deposition in another state? Or why would you be less apt to do something like that than the doctor that you're going to have surgery with, who is so careful that he's going to make sure that everyone throughout the entire process of seeing you through the preparation stages of surgery are going to reiterate that it's the right shoulder that's being operated on, it's the left leg that's being operated on, or the left knee, and that every nurse, the anesthesiologist, the physical therapist, the doctor, every single person you see is going to reiterate what side and what body part you're having operated on. Why should you be any different? Why should you be any better? Why should you not have to go through the steps that all professional athletes have to go through in mastering the fundamentals? That's all that we're really talking about. And I feel strongly that when you do that and you truly understand the need to consistently operate that way with your clients, there will be no way to contain your level of success. And hopefully that will be true with your quiz results also.